My name is Mike Friedland. I'm here with my law school classmate, Rich Segal, and Jeff Kachavan. When you start getting out of law school, you'll see that lots of people their careers have taken a whole bunch of different pathways. Some people stay in law firm practice. Some people go in different branches. Some people take the bench. And so we're going to start today talking about a career transition that I wouldn't say it's relatively common, but it's certainly a lot of people do it is they go from the practice of litigation into mediation. And so I'm very privileged here to be joined by two people who have done that. I'll first introduce our panelist, Jeff Kachavan. Jeff graduated from the University of California at Berkeley with a degree in economics, which is what I did as well. He was just a couple of years before me. He graduated from Harvard Law School in 1980. After law school, he practiced at the terrific Los Angeles firm of Ashell, Grossman and Pines. After that, he practiced at the equally terrific law firm of Pragerson, Richmond, and Luna. And then Jeff transitioned into mediation. That was back in 2001, so he's been doing it for a little while. As long as I've been practicing in Southern California, I've known Jeff as being a premier mediator. Everyone knows Jeff as being a premier mediator. And I should say, not just in Southern California, but nationwide, he's considered one of the very best. Initially, Jeff was a mediator with one of the larger mediation providers, JAMS, but he's been independent for a very long time. He's a distinguished fellow in the International Academy of Mediation. Again, he's someone that absolutely everybody knows. And I've in fact worked with him, I can't remember how many times, to settle very difficult cases. And what I've learned in working with all mediators and working with Jeff is it really is an art, and it's not something that anybody can do. All the mediators approach it different ways. Jeff has his own style. And one of the things that we're appreciative of is Jeff is going to probably talk about how he developed that style and what he's learned along the way and talk about that career transition. So we're excited to have Jeff here with us. We're just as excited to have Rich here with us today. Rich Segal went to Yale, graduated with a degree in political science, and then graduated from Harvard Law School in 1991. Rich will sometimes joke that, we're not the most distinguished members of our Harvard Law School class because we did happen to have like a president and a Supreme Court justice and at least one TV star who graduated with us. But I think that being a member of the class of Harvard Law School class of 1991 is pretty special. Rich is interesting, well, for lots and lots of reasons, but one of the things that impresses me about Rich is he did something I don't think I know anybody else that really did. He went straight from law school back to a law firm where he was a summer associate and stayed there. Rich was a summer associate at Pillsbury. He went from being an associate in litigation to a partner in litigation to the managing partner of the office and stayed there for, I think, more than 28 years of his career before he made the transition. He didn't go directly into mediation. He actually transitioned at first to being the CEO of a charitable organization. If I mispronounced it, I apologize. CASAM?
CASAM.
CASAM. Mm-hmm. It's a charitable organization devoted to providing summer camp experiences for children whose parents have been affected by cancer, suffered from cancer. It was absolutely incredible. And then Rich more recently transitioned to becoming a mediator for ADR services. On that note, I want to thank ADR services for being our sponsor today, providing the technical support, providing the Zoom link, all of those things. So thank you so much to ADR services. With those introductions, I'd like to turn the microphone over to Rich and to Jeff. And I'll start with Rich. What was it that made you consider transitioning to mediation from your litigation practice?
Thanks, Mike. Actually, as you mentioned, I didn't actually go directly from practice into mediation, which is the more typical way of doing it, and either going from practice as a lawyer into mediation or going from the bench into mediation. As you mentioned, I actually left the practice of law to go into the nonprofit world first, and so it was more about wanting to change the focus of my practice. I had been, as Mike said, I had been at Pillsbury for 28 years, a single firm, just sort of rising through the ranks and representing, in general, representing large corporations as a defense lawyer most of the time. And it was 28 years of litigation practice, which I assume most people on the webinar are living that world right now. And, it's in many ways, everything is different every day. And in other ways, everything is exactly the same every day. And it was, every case has a beginning and a middle and an end. And then it just sort of lather, rinse, repeat. And after a while, I just got a little bit bored with it. And I realized I'd been doing a lot of nonprofit work on the side as a volunteer, both either as an active volunteer or as a board member. And eventually I realized that I was getting more satisfaction out of my, world saving than I was out of the practice. And also, fortunately, I had sort of gotten to the point where I realized I didn't need a partner's income anymore, which was sort of an important thing. And so I decided that I wanted to change my focus and retire from my law firm, and look for something more sort of community focused to do. And so I went, and I became the CEO of a national nonprofit for a year, and it was in the middle of COVID. And so I ended up being sort of a crisis CEO. So my time there was limited because of the nature of being a crisis CEO. And then when I left there, I started getting back involved with the legal community, and I reconnected with many of my friends in the defense bar, in the plaintiff's bar, on the bench, and I really enjoyed getting back into it. And I was meeting different people, and I was, several people asked me whether I would be interested in being a legal neutral, and I hadn't really thought about it before. And one of the people who asked me about it was somebody from ADR Services. And I started thinking about it, and I realized that becoming a mediator has a lot of the really good stuff that I loved about being a litigator, without all of the stuff that aggravates people about being a litigator. What I really enjoyed about litigation was solving a puzzle. That was my thing. It was a very cerebral thing. I like to try and figure my way through it, figure out what the answer is, figure out what the proper answer is, be it legally, factually, or financially, as an economic matter. And almost all the time you ended up resolving by settlement. And being able to go in, and I realized that as a mediator, you can go in and help solve the puzzle. You don't have to do the discovery. You don't have to do the battling. You go in and you are focusing on what matters to the litigation ultimately, and help people bridging divides in order to find a resolution and solve the puzzle. So to me, it was the best of all possible worlds. It was using my legal skills, using my experience, and doing the parts of litigation that I really loved. And so I began my career that way.
How about you, Jeff? How did you end up deciding to transition to mediation?
Well, thanks for asking, Mike, and it's great to be here with you and Rich, and thanks to the Harvard Law School Association and ADR Services for providing the Zoom facility for all of us here. So I practiced for 15 years at Litigation Boutique. We thought we were a mid-sized firm in those days in the 1980s. We had as many as 45 lawyers, and that made us a pretty big operation back in those days. So I loved being a litigator. I loved being an associate in the law firm. I thought it was great because, like you guys, spending my days and nights in Langdale Library and enjoying the banter of Socratic dialogue in our 1L classes and all that, it was a pretty nerdy life. When I got into a law firm, be a litigator, gosh, I could give vent to this whole other side of my personality, more aggressive. We got to, beat them. Let's go get sanctions against these so-and-sos and make our client win, and they got to lose. And it was this swashbuckling kind of attitude that was a lot different than ordering a Hark burger and then wasting my afternoon playing pinball in the basement. I found that was great as an associate. When I became a partner, that was the day things started to go bad for me, because I was never able, and it was my own personal shortcomings as much as anything else, that I wasn't really able to develop an independent practice, my own clientele, my own real first chair litigation career. It was very frustrating to me, and I was not happy in my career as a litigator as we got beyond the associate part and into the partnership part of it. And around the time when I was starting to become unhappy, We had a client who was stuck in a piece of commercial litigation, and I want to disagree with Rich a little bit. He said litigation has a beginning, a middle, and an end. Sometimes it seems like it has no end. And that was the kind of lawsuit in which we found ourselves involved, representing a financial institution. And the client just wanted a way. They wanted a respectable, face-saving, legitimate way out of this troublesome case on which they were spending too much money and was too disruptive to management. And we had had some just meetings with the other lawyers to try to discuss settlement. And I think one lasted 7 minutes and one lasted 11 minutes. That was it. And I knew a guy who would become a mediator. So I spoke to him. It was a Richard Millen. He's a wonderful man, Harvard Law School graduate. And I said, Richard, what about all this ADR stuff? This was around 1992, probably. And he said, well, there is this thing called mediation, and I'm probably not the right guy to be your mediator because you and I know each other. I used to be of counsel to the firm, but I got another guy named Bob Hodis, and he would be a great mediator for you. So I broached the subject of mediation to the other side. We knew so little about it that an associate from the opposing counsel's law firm and I had to go to a Los Angeles County Bar Association program on mediation together to see just what it was and whether they would recommend it to their client. So we did. We had the mediation. It lasted 6 hours, and a lawsuit that had been pending over 3 years settled. I thought, wow, this is pretty cool. So I wanted to learn about this. So I started going to mediation trainings because there was no such thing in those years as negotiation training or mediation advocacy training. And I really tried hard to avoid the role of playing the mediator in the role plays because, I was a rootin' tootin' Harvard law educated litigator. What would I be doing in the mediator's chair? But you can't avoid it. So I thought, well, this is not so bad. And we were encouraged to do pro bono at the work at the firm. So I started taking some free cases. They shouldn't really be called pro bono cases when they're through these court-annexed systems because you're working for rich people, not poor people. But they're free anyway, and it's somewhat of a public service because it lightens some burden on the court system. And gee, these were going pretty well. And then things were just deteriorating at the law firm. I left. I joined in with Dean Pragerson, who then went on to enter the family business of Article 3 judging, like his dad did. Very distinguished, the Pragerson family. They're wonderful, wonderful people. And I practiced with Dean for a couple of years before he became a federal judge. And then it was, oh, geez, Dean is bringing in all the business. What am I going to do? There's enough work certainly to keep me busy for 6 months, maybe 12 months, but by a year and a half from now, there's going to be nothing left. And I just couldn't figure out how to generate business as a litigator. But I thought maybe now is the time to jump in and make the change and become a mediator. I had some money in the bank at the time. You have to have a financial cushion because while you're building the factory, you have no widgets to sell. And because I had the financial cushion and I had taken mediation training and cut my teeth on a lot of these free cases, I thought now is the time. And I said, I'm not taking on any more litigation matters, not that they were streaming in anyway, but now is the time. Now I had some new business cards printed up. Today I am a mediator. And then you come to your office and you say, well, gosh, what does a mediator do when he goes to work in the morning? I recognize that staring at the telephone is not going to make it ring any more than it's going to make it levitate. Got to get off my rear, start going to all the rubber chicken dinners, the bar association events, writing some articles, there was no social media at the time, but just getting out there any way I could to reestablish my professional identity as a mediator rather than a litigator. And I would say to people who are considering this that you have to recognize that it takes time. You're not just going to hang out your shingle and oh my God, people are going to think you're God's gift and start calling you. It takes a lot of work, and it continues to take a lot of work. I've been mediating for almost 30 years. You still never know really where your next case is coming from. Nobody has a contract with you. So I'm always out there at uh, conferences. In fact, today I'm doing an in-house CLE for a law firm in San Francisco. I'm doing this webinar from a hotel room in San Francisco where I'll be doing this program at lunchtime. So that part of it really never stops. And having a financial cushion is so important because you are going to have this period of time where you'll be doing cases for free through court systems, and getting the paying business to come in takes time. One thing that many people are reluctant to admit, but it's true, is they have spouses who have jobs with good health insurance. Because if you don't have a spouse with a job with good health insurance, particularly if you have young kids or dependents, man, getting good health insurance is a very, very expensive proposition. So there are just a lot of practical things you have to think about before you become a mediator. I hope that's a good kickoff to our conversation today.
No, that's great, Jeff. You touched on a bunch of really interesting topics. So, Rich, what did you do to prepare? I mean, I know you mentioned that you did the thing that is important, which is to be a really well-established, highly respected, extremely personable litigator in San Diego and Southern California. So you had an amazing reputation, but how did you build your identity as a mediator? What types of things did you do to prepare?
Well, right. I mean, I have to agree with Jeff, is that changing your reputation in people's minds from a litigator to a mediator is very difficult to do. Everybody told me when I started this that it's going to take a lot of time, a lot of effort, and it's going to be slow. And to a certain extent, it's an ego blow, because you're out there either getting marketed, or you hang the shingle out, you do what you're doing, and then you hear a lot of crickets, for a good long time. And the things that you do take, a lot of time, because you have to remind people over and over and over again that this is what you're doing. And, because I didn't go into the mediation world consciously, like I had 2 years lead time where I knew this is what I wanted to transition to, I had to rely on things that sort of already were there. And as Mike mentioned, some of the things that I find most important and most helpful, honestly, were that you have to be well known. People need to know who you are, because it's a personal business. You need to this is not like when somebody files a lawsuit, you get assigned to the judge. The judge has a never-ending source of work because they just get assigned. Mediators have to be selected and agreed upon by both sides. And so in that case, you have to be somebody that they know of. You have to be in their minds that's somebody that they want to think about. And you have to be somebody who's agreeable to both sides. So having been a defense lawyer 99.5% of the time, most of the defense counsel that I knew through either professional organizations or as co-defense counsel in different cases, or but working on the same side of cases with them. And the plaintiffs' lawyers that I knew were my opposing counsel. All right. And in this day and age, getting along with your opposing counsel is not as easy as it used to be, because the expectations of the clients and of just the world at large are such that the adversary process has gotten much more adversarial, as opposed to cooperative over time. I started practicing 34 years ago, and in San Diego, we used to pride ourselves in something of a gentle person's way of practice. And our whole point was like, don't be like those New York lawyers, which eventually became, don't be like those LA lawyers. but it was, but getting along with your opposing counsel and and having a good reputation in the community with opposing counsel, with co-counsel, other counsel, and with the court is vitally important, because all you are selling is your reputation. All you are selling is your skill set, what people know of your skill set, what people know of your personality. And if you're one of those defense lawyers that makes all your plaintiffs lawyers hate you, they're never going to agree to use you as a mediator. I didn't practice as, a gentleman because I thought I was going to be a mediator and I'd need that later. I did it just because that's the way I am. I don't see any reason to be a jerk if I don't have to be. And one of the things that got recognized when I was looking at mediation was that I would go to an ABTL meeting, for example, Association of Business Trial Lawyers, and after I had been retired for a couple of years, and I would get big greetings from defense lawyers, plaintiffs lawyers, and judges. And it was noticed that, like, wow, everybody seems to like you. And that's one of the things that's very important. So, and having a reputation for being a good and respectable lawyer who's skilled in your field is important, because that's something, that's one of the bases for parties choosing their mediators nowadays is there's the benefit of gravitas, somebody who might have, HON period at the beginning of their name, somebody who, has a sort of command persona. But then there's also expertise, because a lot of times parties with complicated cases don't want to spend the first half of the mediation explaining to the mediator what the antitrust law means or something like that. And having somebody who is known to be expert in certain areas will help you get business in those areas, because you speak the same language as the matters at issue. So being, good at what you do, being known for being good at what you do, and frankly, being nice to people is some of the best preparation that you can do, I believe.
Mike, let me underscore something that Rich said. So I was at an ABTL dinner here in Los Angeles some years ago, and a guy who'd been a judge in LA County Superior Court, retired a couple years previously, comes up to me and he says, "Jeff, I just don't get it. I've been on the bench for so many years, and I retired a couple years ago, and trying really hard to market myself, and I'm get a case here and there, but just not clicking. I don't know what's wrong." And I said, "Just stay with it, Judge. You're coming to these events and networking. You're being in front of people. Keep it up, keep it up." But what I thought to myself was, "Well, you so-and-so, you spent 20-something years on the bench yelling and screaming at lawyers, sanctioning them if they didn't have their page numbers right dead center in the middle of the page and their exhibit tabs in perfect order, embarrassing them repeatedly in the minds of the vision of their clients sitting right there. And now you expect people to pay for the privilege of spending time with you? Good luck. Good luck." So Rich is right. You establish your persona, or your reputation, your character over years and years of experience. In terms of what you need in terms of past experience and whatnot, well, I tend to look to the future more than the past. And I see people who've succeeded as mediators from every walk of life. And we have people, there are people, Lee J. Berman is a good example here in Los Angeles. He's not a lawyer at all. He was in the real estate industry before he became a mediator. He's an outstanding, highly skilled mediator, very successful. So no matter how experienced or inexperienced, young or old, whatever your background is, there's a way, and everybody invents their own way. And do you have to have subject matter expertise? Well, yes, you have to know something about the subject matter of the dispute. Let me say, though, that in an age of artificial intelligence, I get prepared. I got called on a couple of months ago to mediate a case in an area where I knew nothing. I don't know why they hired me, but I didn't know anything about this area. So I went on ChatGPT and I typed in a few questions. What do I need to know? What are the usual areas of negotiation push and pull that I didn't upload the mediation briefs. I didn't put any confidential, not even the names of the parties or the lawyers into chat. Just I'm mediating a case under Section X of this statute. What are some terms of jargon that I need to know in order to sound intelligent? What should I avoid asking so that I don't sound like a total rube? And with about a half an hour of interplay with ChatGPT, I felt pretty well prepared, and my general mediation skill was able to get me through. General mediation skill is the second thing, in addition to subject matter expertise. Mediation skill is very hard to measure. How do you measure? Is somebody empathetic? Somebody a good listener? These things are very hard to measure. There are proxies for it, though. To me, the most important proxy is, does the mediator know how to facilitate and run a joint session? As unpopular as they are in the eyes of some lawyers, let me tell you, when people get together and talk to each other, they do things that a mediator cannot possibly do. They can speak with knowledge of the case that the mediator is never, ever going to have, because we just get a brief a few days, a week or two, maybe in advance. The lawyers speak with conviction that the mediator is never going to be able to muster, because they're not our clients. We don't have the duty of undivided loyalty to them. You can decide what to maintain confidential and what not when you're speaking directly to other people. Things that you might not want to tell them, you might decide to be more forthcoming or less forthcoming, depending on the way the conversation goes. And God forbid somebody should ask the mediator a follow-up question if a mediator is speaking on behalf of somebody. How do we know how the lawyer would want that question answered? So there are tremendous benefits from having some, not just unguided missile type joint sessions, but there are plenty of benefits from having tailored and curated joint sessions with each other. If a mediator says, well, I don't know, I never do those, they always backfire, that would be like a lawyer saying, well, I don't do summary judgment motions. I just don't do them because they never get granted. And you know what? I don't oppose them either because they always get reversed. And if a lawyer said that, you think, oh my God, I'm not hiring that lawyer. Similarly, if a mediator says, oh, I just never do joint sessions, they don't work, it means the mediator is lacking a fundamental skill and should be avoided. The third thing to take into account with a mediator is the mediator's personality. There's no one mediator who's right for every case. You're not going to get along well with everybody. Somebody may look at Rich or me or any other mediator and say, oh, he's going to get along great. He's a perfect person for this case. Or they may say, oh, Kitchaven, with his corny sense of humor, he's going to turn off my opposing counsel or the client, whatever. And you know what? You just learn to live with that. You hold yourself out authentically and consistently. You will find the audience, the market that's right for you.
So I'm going to take a question from the audience, and I'll pose it to both of you. We've been talking about transitioning solely in the context of mediation. Lots of mediators do arbitrations as well. There are some arbitrators that don't really do mediations. Rich, was there a reason that you angled toward mediation, not arbitration, or unless the answer is actually you do both of them, and we just happen to be talking mostly about mediation, not arbitration today?
Well, actually, at the beginning of my career, I will certainly do anything that comes in the door. No, that's actually slightly an exaggeration, but no, I will do arbitrations, but I prefer mediations. And the reason I prefer mediations are that it's an entirely different skill set, honestly. And they're both puzzle solving, but one of them is, you're acting as a private judge. And you're following the rules, and you're following, what the law says, and you're restricted by what the facts say. Whereas as a mediator, you can craft a solution that works for the parties, no matter what the law is, no matter what the facts are. It's just what the parties are willing to agree on based on what their interests are. And you can go outside of the pleadings, you can go anywhere you want. One of the shorthands that I said also is that, arbitrations tend to be much longer in duration. They go on for months, whereas a mediation very often can resolve in one day, or one day plus a bunch of phone calls. I mean, I've been in mediations where they go on for weeks, and they're, you have repeated sessions, but for the most part, they're much more compact. And so mediations, from the mediator's perspective, the tagline that I've used with people when they ask me about this is I say, when you're an arbitrator, you have to be right. When you're a mediator, you just have to be good. Because you really do want to get the answer correct when you're actually judging and being a trier of fact and somebody who's ruling on legal questions. When you're a mediator, you just have to be effective. You just have to help the parties agree on whatever they want to agree on. You're not deciding what's correct or incorrect. You're not deciding what's a good deal or a bad deal. You're just helping them get to a place where they can step out of the courtroom and go back to their lives. And I just, from a personal standpoint, I find it more fun, honestly.
How about you, Jeff?
I think it's more fun to be a mediator too. Other people, their nature, their personalities takes them down the path of arbitration. I think that's great. One of my law school classmates, Jay McCauley, is a fantastic arbitrator, and he does some mediation as well, but he really focuses on arbitration. And I had a long conversation. He's a great buddy. I talk to him all the time, and he loves talking about the question of arbitrability, and does the judge decide or does the arbitrator decide? And when he talks about it, it's with such expertise and such depth and such nuance and such mastery. I think I listen to him and I think to myself, I would have no business holding myself out as a professional arbitrator because I don't know any of this stuff. And arbitration is it's just different. It's just not the same thing. It's like, well, you could be if you're a doctor, you could be an ophthalmologist, or you could be a ear, nose, and throat doctor. Well, they kind of operate in the same neighborhood, but they're very different things. So similarly with arbitration and mediation, yes, we arbitrate in the same sort of neighborhood of ADR, but they're very different things.
Is there anything, and I'll start with you, Rich, is there anything that you wish you'd done to prepare that you didn't do? And this, I guess, is advice to someone who is who's thinking about following in your footsteps a few years into this. What would you tell them to do? You say, gosh, I really wish I had known this. I wish I had done this.
Yeah, there is one thing. I mean, again, I decided to go into the ADR world without several years of preparation to do that. That was not the transition that I had originally planned. And so I found myself in a situation where, from a credentialing standpoint, my credential was I have a bar number, I have a whole lot of experience, I have a big fancy pedigree. But when it came to actual training recognized by organizations or the state bar or any sort of professional certification organization, I didn't have any of that. And in certain cases, as Jeff mentioned, a lot of times when you start up, one of the things that I'm doing is I'm volunteering for several pro bono programs, and there are requirements that educational requirements for you to have before you can actually even give away your services for free. And I didn't have them before I started, so I had to play catch up. I had to, over time, over 28 years of practice, I had gone through 1 million CLE hours, and some of them had to do with alternative dispute resolution. When I was litigating, I was very often fighting over whether something, should be in arbitration or in litigation. So actually, it was an area that I knew quite a bit about. But when it came to boxes to check saying, have you had 32 hours of training in this area, I had to go back and flip through a whole bunch of forms to try and figure it out. And I ended up taking a course offered by the LA Superior Court before I could even volunteer for them. And so if this is something that you're interested in doing, there are training programs that are available that will get you something you can put on your resume to say, yes, I have actual training in alternative dispute resolution, and it'll also satisfy a lot of the obligations that you have if you want to join different programs that are offered as a way of marketing yourself and contributing to the community. There's the Strauss Institute at Pepperdine is one that's very well known, and Harvard Law School actually offers a very well known program in alternative dispute resolution. The advantage of the Strauss Institute is it's here in California, and Harvard is offered less frequently, and you get to / have to go to Cambridge, but it's. But I would probably look into some formalized training beforehand. It's not critical, but it's helpful.
How about you, Jeff? Is there something you wish you'd done to prepare?
I would go back to what Rich said. You just have to be good. You just have to be good. And how do you get good? You get good through training and experience. I think mediation training is essential because you have to unlearn a lot of what you do as a lawyer. As lawyers, we're trained to be able to argue any side of any issue. And that quickly devolves or evolves into taking great joy in arguing any side of any issue with anybody you happen to be talking to at any moment of the day, right? We all have to learn to kind of put that in the back seat at home. Many of us learn that, some of us don't. And you have to learn it as well in mediation. People come in, the only way they've dealt with this subject matter is by arguing for months or years. And as mediator, you have to unlearn the lawyerly trait of arguing and do something else instead, which is generally have conversation rather than argue. So I think mediation training is essential, and the Harvard program, the Pepperdine program, Lee J. Berman's private program, I believe he calls it the American Institute of Mediation. There's a lot of good mediation training out there. Experience. Many of us get this experience through the court-annexed programs. They are not pro bono. They are not pro bono. Pro bono publico. When you think of pro bono publico, you think you're doing it for the Legal Aid Society or sort of people who can't otherwise afford legal services. When you're doing these programs, cases through the court program, you're doing them for international insurance companies, AmLaw 200 firms, Fortune 500 companies, which are not entitled to pro bono anything. So it may be pro bono mediator, but it's not pro bono publico. And then people say, oh, yes, but you're helping the court system. Yeah, right. So are all the lawyers. Can you imagine a court system without lawyers simplifying and making clear for judges exactly what they have to decide? That's the whole reason the legal profession was invented in the first place, to frame issues and make it non-chaotic for judges to decide issues. So if it's so wonderful for us mediators to help the court system, the lawyers who are helping the court system even more, they're not working for free. Why should it be presumed that mediators always work for free? So yes, do the cases through the court system to get experience, then get off those court panels as soon as you can. Why? What I found in my experience was people were just exploiting me. People would call, they say, Jeff, you're on the federal court panel and you're signed up for 3 or 4 cases a month. And gosh, we've got one here we'd love to bring to you. Won't you make an exception and just take our additional case for free? So I found it was just working for free because people were calling over and over and disrespecting me and disrespecting the limitations of those court panels. So I think that in the development of one's mediation career, it is important to be on those court panels for a limited period of time and then recognize when it is time in terms of your own self-esteem, your own self-respect, and being properly compensated for the good work you're doing to get off those court panels. Other things that I wish people had told me early on, yeah, everybody tells you it's going to take a long time. And everybody then says to themselves, yes, but in the case of moi, perhaps not. And that's, I mean, we are Harvard men after all. And, I'll never forget one moment in a land use planning class with Professor Charles Haar, when some guy's ranting on and on and on about some insight he's had. And Haar is standing at the front of the classroom listening to this and just sort of nodding, and he's drumming his fingers on the podium. And then finally this guy runs out of gas and stops after this endless monologue. And Haar goes, ah, the happy arrogance of the Harvard man. And, there's a point where we have to put the happy arrogance serves us well in terms of our belief that, we can just invent these new careers for ourselves. Where do we start? Let's go get them. And that, in that sense, the happy arrogance serves us well. We also have to learn a happy humility along the way, that it takes time, that we're not the right mediator for every case, that you just have to think of, nobody has a contract to hire us. Every time two or more sets of lawyers and clients agrees to hire us, we just have to say a prayer of thanks. It's a blessing that we get this work and we're able to do it for people.
Mike, can I just
You-
jump in? I want to
Please,
disagree
please.
with Jeff a little bit on the pro bono programs through the courts. Um, there are, like, for example, I'm doing a pro bono case on Monday through the LA Superior Court program where the total amount in controversy is $35,000. All right. There's no way that they're going to hire a mediator for, $7,000 to $15,000 a day to mediate a case where it's $35,000 dripping wet. And if there's no volunteer mediator, there's no mediation, honestly. And so there are cases, and I do handle cases like that where they're too tiny to actually, hire a professional mediator. And those cases usually resolve. They just need some help. And so yes, there are certain circumstances when you might be taken advantage of because somebody who could otherwise very easily pay you just doesn't want to. But there are cases that you really are providing pro bono mediation services, like somebody would provide pro bono counsel in a case where they basically wouldn't have counsel otherwise. And for somebody at the beginning of their career, and I think Jeff acknowledged this already also, so it's not a disagreement, is that getting exposed to these larger firms, through these programs where they are not paying you initially, and then they say, wow, this guy's great. And this is something that's happened to me where I've gotten cases where I started off on a pro bono case with two lawyers who could have hired me as a mediator, but they didn't know me from Adam. But then they hired me through the through the pro bono plan, and I got comments back from one of those lawyers saying, "Wow, you're great at this, and I'm going to put you on my short list." And I already got an inquiry from him, like a month later on a paying case. So so it is, a business development tactic. And as Jeff mentioned, eventually you're not going to keep letting MLaw 100 firms use you for free over and over again when their clients clearly can pay for you. But at the beginning of your career, it's a great way to, to bite the bullet and do that.
As you're talking about, and I've been through dozens and dozens, if not over 100 mediations as a participant. And one of the things that I always found very satisfying, I think it's something similar to what you had said earlier, Rich. I always found it personally satisfying to solve the problem, right? Isn't that great? And I always had this feeling, the mediators say this always as a matter of road, that, the good settlement is where both people walk away angry. I've never really believed in that. I've had lots of them where both parties walk away, they didn't get the tens of millions that they wanted, but they knew that it was a good outcome. Both sides were happy. And I always found that pretty satisfying. And I'm imagining, like, in terms of like the ones that we're talking about, the pro bono, obviously both of you agree it's a good way to it's a good way to get yourself established at the beginning. But the way you were talking about like the $35,000 cases, Rich, it sounds like it's kind of personally satisfying to you, putting aside the money. Is that right?
Yeah, I mean, I'm the same reason I did pro bono when I was a practicing lawyer. I'm doing it now. It's that it's the reason why I left the practice of law, the private practice of law, in order to go into the nonprofit world. Is that it's time to try and make the world better, in my mind, and if I can help people resolve their disputes so that this isn't something that they're thinking about, while they're lying in bed ready to go to sleep at night, and it's something that's important to them. I mean, somebody who's actually litigating over $35,000, it's obviously something that matters to them, because nobody's going to litigate over $35,000 if it's not relevant, and as an amount of money. It's just, for a lot of people, it just wouldn't be worth doing. But for these people, obviously, it is worth doing, and it's important. And you have a lot of personal, conflicts going on, and helping them to resolve that is personally satisfying. And it's and again, it keeps my brain functioning well, where I get to go in and be a superhero in a certain way. And I think I'm adding to, I'm helping the court system, I'm helping the parties themselves, and it makes me feel good when I do it.
One other thing, when most people who've litigated a while, people will approach them. People have approached me and said, have you ever thought about making that transition? And when I thought about it, I thought about things that I would miss about practicing law. And one of the things that I think I would miss, or I thought I would miss, is working with people. Like I like working with my fellow partners and associates and having this common task. And I felt like if I was mediating, right, then I'm the island, right? I come in, I walk into somebody's room and I talk to them, then I leave and I go into my little conference room where I talk to somebody else. But I'm sort of in my own little silo apart. Mediators I've talked to said, no, that's not true. I actually feel, this is a mediator that I work with also, that's well known in Southern California, Gail Migdal-Tidal. She said, no, that's not true. It's even better than being on one litigation team, because you're on two teams. You get to play with you get to work with both teams. But I wanted to ask both of you, and I'll start with you, Jeff. Are there things that you miss about litigating?
Of course, everything is a trade-off, Mike. There is the sense of adrenaline that you get when the gavel swings down and the judge has ruled in your favor, the jury comes back your way, and you have this triumphant feeling, and you feel that if you jumped out of that window, you just float on the air. You have this great euphoric feeling. And as a mediator, you have a great sense of satisfaction when people either settle cases or make clear, strong decisions that maybe now is not the right time to settle a case. And there's a feeling of great satisfaction in that. It's not the same thing as the feeling of satisfaction of when you beat them in court. There's a sense of what am I going to be working on tomorrow? There's a sense of security. When you're a litigator, you know that you've got a case and it's cooking along, and you're going to be working on that case this week, next week, this month, next month, this year, maybe even next year. As a mediator, I have my practice has always had relatively short set times for cases. I book cases generally 3 to 6 weeks in advance. So I'm like a restaurant. I got reservations. People are coming for dinner this Saturday night, next Saturday night. But 2 months from now, is anybody going to be coming to my restaurant? I don't know. So I do miss that sense of security sometimes. At the same time, I have a great sense of adventure that when I go to an ABTL dinner, some bar association event, I look out at all these people. Most of them are younger than I am now, and I am of two minds. Uh, One part of me says, how is it possible that I've been practicing law in this community for 45 years now, and there are all these people I don't know? And then the other part of the side of that coin, flip side of that coin is, isn't this great? I know all these people already, and here's all these new people for me to meet, and new people who may need my services from time to time. It's a great adventure and a great exploration. And I try to emphasize that side of it.
How about you, Rich? Are there things that you miss?
A little bit. I mean, most of what I missed when I sort of left the legal community entirely was all of my friends and colleagues in the legal community that I had built up over almost 30 years at that point. And yeah, you worked with a lot of them day to day, but you also worked with people sort of periodically. Your opposing counsel, your lawyers at other law firms, people in organizations that you're involved with. And you can still do that when you're a mediator, because you still, as Jeff mentioned, you still go to a lot of rubber chicken dinners. You still, see people at different events. You stay involved with things, with organizations. I'm still an active member of ABTL. I go to all the meetings just like I used to. I still see my friends. And also, my experience is different, at least at the moment, from Jeff's, is that Jeff's, independent, and I'm with one of the big four, ADR services in California, also called ADR services. And so I have a new group of colleagues, one of whom is Gail Tidal, who you mentioned. Gail was actually very nice to me when I first started out, and I shadowed her on several mediations. She took me under her wing, to sort of help train me along the way as I began. And so you have all these new people that you're meeting, and you maintain contact with your legal community by mediating. And frankly, you're kind of doing you're doing something which is more pleasant for them. As a litigator, I always used to joke around that the corporate partners, the transactional partners in my firm, would always have something positive to sell. They'd be able to talk to a client and say, hey, I can get you financed, or I can get you merged, or I can get you, something cool. Whereas a litigator is sort of like a vulture circling, waiting for something to die, because, you're only there when something bad is happening. And as a mediator, I can be more of the person who comes in and says, okay, I'm going to help solve a problem for you. I'm going to give you something positive. I'm going to be, somebody that you're going to be happy to see and come in. And so you actually can maintain your relationships with these people that, in a way that actually sort of brings them something where at the end of the day, they're going to be smiling and thanking you and relieving stress, as opposed to sort of helping them, deal with it on a day-to-day basis. So yes, there are some things that I miss, but not a lot, honestly.
In some senses, when I go to a conference or bar association lunch, I never have to leave because somebody's getting on the phone to give me ex parte notice, or some associate is calling with some disaster that's not a disaster at all. One nice thing about being a mediator is that our nights and weekends are our own. We don't worry that there's some opposing counsel staying up late trying to embarrass us and make us look bad. So in some senses, when I'm with people, I'm more undistractedly with them because I don't have these nagging fears in my mind that opposing counsel is working hard. Why am I not working? I know we have a couple minutes
Sure, of
left.
course.
And, the question of small cases, people on the $35,000 case are paying their lawyers something. It's probably not a pro bono case for the lawyers. When there are costs in the case, those costs are probably passed on to the client. The lawyer is not absorbing them. And so the question comes up, working for free for people like that, in cases like that, has larger implications. Some of the implications, and this became very clear to me when I was president of the Southern California Mediation Association 20 years ago, has serious implications for the growth of the mediation profession and diversity in the mediation profession. Because the mediation profession is about as male as the Green Bay Packers, by and large. There's some women succeeding, but the women will tell you that they feel it's a man's world. And it's hard for young and more diverse mediators. And when mediations in cases like that are done for free, and we do not allow price to intervene as the mediator of price, as the mediator of who gets to do mediations, there are implications there that I saw very clearly when I was president of SCMA on the ability of younger and more diverse mediators to enter into the field. Because when people go to a court system and they see Harvard Law graduates and people with the kind of experience that Rich and I have, and people like us have, on those panels, they will definitely pick us. What that does is it deprives younger, newer, more diverse mediators of the opportunity to compete based on price for these, shall we call them, entry-level cases. And if we want the field of mediation to survive and thrive, if we want younger people, if we want more women, if we want more diverse people to come in, we have to allow price to dictate who gets these, shall we call them, entry-level mediations. This is one reason that I have taken the position publicly that the court-annexed panels, as a matter of public policy, serve some salutary purposes, yes, but they serve some very detrimental purposes as well to the growth and vitality and health of the mediation profession. I talk about this every opportunity that I get because, I'm now I've always been the class of 1980. So, I'm at the point where I've only got 20 or 25 more years of work as a mediator ahead of me. So I'm starting to look more towards what the future of the field might seem to be. So I would caution anyone watching this to keep in mind, and it's a Harvard Law School program, so I think that taking the more statesmanlike, long-term, diplomatic, big picture view is appropriate for people with our backgrounds and our educations. And then when we look to the future of the mediation field, not to forget that allowing price to be the basis on which newer, younger, more diverse mediators can compete, the impact that that has on the growth of the profession in a positive direction is significant. And I urge everybody listening to this, either live or on the recording, please keep that in mind.
Jeff, thanks so much, and thanks for that impassioned plea. It's a very thoughtful perspective that I hadn't considered before, and I think everyone listening and watching is going to be thinking about that. Thank you so much to both of you for your time today. Lots to think about for everybody. I really appreciate all of the comments you had. I know that the comments that I've been seeing, people appreciate how frank and candid both of you were. Incredibly helpful. I've worked with Jeff before. Jeff is a fantastic mediator. Rich, I've known forever, and I haven't had yet the chance to work with him as a mediator, but I hope to in the future.
Get on that.
Yeah. Look, Mike, having had the opportunity to go to Harvard Law School, truly one of the great blessings of my life. And that my parents allowed me they paid for it. They encouraged me to go across the country to do it from California. And it's awesome. And I'm happy to have the opportunity to give back through this webinar and otherwise. Thank you.
And thank you again to ADR Services for sponsoring and hosting us today.
All right.
Thanks so
care,
much.
everybody.